There we go. So today, we're going to talk about finding an attorney and working with an attorney, what you need to know about attorneys, how to prepare for the first consultation, the things that you should be asking, lists of questions that you should have for your attorney, and then lists of things that you should be thinking about before you meet with your attorney, information that you should be collecting prior to meeting with the attorney and prior to kind of making decisions, and then how to decide once you've got an attorney if you should change an attorney. And that happens a lot. It's kind of a big question. And the next time we do the workshop will be in 2 weeks, and we'll talk about fees. How much does it cost to get a divorce? How can you save money? How can you minimize your costs and maximize your budget? Flat fee options, limited scope options. That'll be next time. The remainder of our 11-part series will go over disclosure and discovery, pre-hearing conferences like a resolution management conference or return hearing, divorce negotiation tactics, and the divorce negotiation process, which is pretty much mandated through the court and highly encouraged. Trial preparation and trial presentation. Now this is gold. If you're going to be representing yourself in court, you need to know things like how to present evidence, how to select evidence, how to organize evidence. So we'll go over that in our 6th session. After that, we'll go over legal issues. So the first half of the, up to, let's say, session 5 is really procedural, how to procedurally get through the process. And then after that, we go into the more substantive issues surrounding the matter, like the divorce legal issues, child custody issues, how to develop a parenting plan, that sort of thing, red flags, and then golden provisions that you can put into your parenting plans. Child support, how that works, all the ins and outs, how to deal with the division of economic security and getting income withholding orders and that sort of thing. And then we'll talk about spousal maintenance and alimony and property concerns. That will conclude our 11-part series. And at that point, we'll probably take we'll see how you like it and whether or not it's helpful, and then see whether or not we want to offer it again or we want to offer something else based on what it is that you want. So please do give us feedback, because we will make changes based on what works for you. Before we do anything, we have to start out with kind of the big picture. And this is the big picture plan that you can use, or guide that you can use when developing your plan, because divorce, from our perspective as lawyers, is kind of a legal process. It's a transaction, it's a legal process. But for you, it's way more than a legal process. We're talking about restructuring your entire life and determining the direction for the rest of your next phase of your life, the next chapter of your life. So with that in mind, I like to tell people to start off by figuring out where you're at right now and what is it that you're trying to accomplish, not legally, but for your life. What are your goals? And then determine, what are my resources? Because if your goal is to, let's say, I don't know, move out of your 3,500 square foot house and get a new 3,500 square foot house, but your spouse is paying 3/4 of your 3,500 square foot house, you may want to reassess those goals based on the actual resources that you have. So this is about determining what your goals are, determining what your resources are, and then trying to come up with a realistic plan. And that takes us to kind of step 2, which is planning your finances and figuring out your budget. What's your budget today? What's your budget going to be during the period of time that you're going through your divorce or family law matter? Let's say you may not even be married, but if you're living together and then you're moving to living on your own, you're going to have to reassess that budget. Number 3 is figuring out a plan for your kiddos. What's going to happen temporarily and then long term. And this will be highly dependent on your goals, which is why you have to start with number 1. Where are you going to live in relation to your soon-to-be ex-spouse or partner? That's going to impact your child custody plan, which is why everything has to start with number 1. After that, we're going to look at your balance sheet and figure out, okay, well, what do we have as far as property and debts? That's your balance sheet is, what do I have for property and what do I have for debts? In Arizona, it's a community property state. So if those assets and debts were accumulated during the marriage, they're largely going to be divided. And it doesn't mean that each single piece of property has to be divided, but the whole of debts and property essentially is divided. And most often it's divided equally. Equitably is the law. most often equitably is equally. It doesn't mean it's always that way, and it doesn't mean it's dollar for dollar, but in general, that's what you're doing. Number 5 is protect yourself on social media. And this isn't social media. This isn't limited to just social media. This is about kind of protecting your privacy and your reputation as you move forward, and trying to be as intentional as you possibly can while you manage a very emotional transaction. It is human nature to obviously want to talk to your friends and family. And these days, it's really easy for us to fire off a shot on social media that's clearly geared towards your ex or your situation, and you really need to take some time to think about that and determine who it is you want to be 2 years from now or 3 years from now before you start posting on social media or talking to friends and family or spreading intimate details about your breakup. Number 6 is assemble your support team. And this is really where we're at today. This is who's your lawyer going to be if you're going to use a lawyer? Who is your counselor going to be if you're going to have a counselor? Who is going to advocate for your children if you need kind of a third-party neutral? What type of a team do I need in order to get me through this? And who are my family and my friends that I can really trust and bring in? And who are those family and friends that maybe are great family and friends to go out with on Friday night, but they're not necessarily the family and friends that you want in your situation? It's important that you have people around you who are level-headed and calm and grounded, and not those people that we all know that kind of fan the flames and feed off drama. Do some intentional soul-seeking on this when you assemble your support team. All right, now we're going to get into specifically talking about attorneys. Everything you need to know about attorneys and how to work with attorneys. Do you need an attorney? Not everyone does. If you've got no assets, no debts, no kids, and you're not fighting over anything, then I don't know why you need an attorney. You need the right paperwork to get yourself split up, but you may not need an attorney. If you've got separate property issues, if you've got other tricky legal issues that we'll cover later in the workshop series, then you probably do need an attorney, but it doesn't have to be all or nothing. You might need an attorney to review your paperwork or guide you through the process and maybe be your behind-the-scenes coach. It doesn't necessarily mean you need to shell out all of your life savings to your attorney. And you definitely don't want that person to be your emotional support. And that's why when we look at that support team that we talked about building, we should know the role that your attorney plays. Your attorney is simply too expensive and not qualified to be your emotional support system. But you will need an emotional support system. And too often people don't have that set up and do try to use attorneys, and we do the very best we can, but we're ill-equipped and not qualified. Once you decide whether or not you need an attorney or for any reason at all, you're going to prepare for your consultation. And this is all about asking the right questions and knowing what you want before you go in. And we've got a handout for you that I'm happy to email you, and we're going to go over how it is to best do that. And then after you figure that out, then you're looking at having all of the information ready that you need for your attorney during that consultation to give you the best and most accurate information. When you give them the information they need, they're going to be better able to maximize the use of that time and give you the best information for your situation. This is a long list of questions, and we're going to break them down and go through them in groups. This first set of questions is really about how you can determine if your attorney, if the attorney that you're meeting with is qualified to take your case. So these are some questions that you might want to think about asking. You are looking for, I guess we'll talk about that as we go, but you're looking for the right fit. And the right fit is more than just education. It's more than just experience. It's really a combination of experience, education, and fit, and click, and culture fit, and value fit. So these questions that we've developed will help you determine all of those things. All right, so when you're in your consultation, one of the things you want to ask is who will work on my case. It is not unusual for the person that you meet with in the consultation not to be the person that works on your case. We do that often here at Modern Law. I like to do the majority of the consultations, but sometimes I'm not the best fit for a case. I might be too expensive to take a case, or it might be a case that somebody else in my office is better suited to take given their niche. And we here at Modern Law really do have the attorneys who all work in their specific niches so we can be most effective for clients. So it's worth talking about who's going to work on my case and who's going to be my team. So in Modern Law, we'll have, I usually do a lot of the overarching strategy and that sort of thing. You'll have usually an associate who will work for less money on things like gathering paperwork and that sort of thing. And you'll have a paralegal, and then you'll get to know our billing team, that sort of thing. So you want to know who's the team. You want to ask the attorney, what is your educational training and experience? What's your background? What makes you qualified? How long have you been out of school? What have you been doing since school? Let's say you worked for a nonprofit. Let's say you've been out of school for 15 years, but you spent 10 of them in a nonprofit. That might not be okay with you. You just want to ask. And maybe it is okay with you. It doesn't mean that it can't be okay with you. It just means you want to ask. Just want to know. How many cases like mine have you handled as a firm in the past year? So it's not unusual for lawyers to dabble. It's not advisable, but they do. So if you walk into a firm and you're meeting with an attorney, it's going to be worth asking, how many actual family law cases have you worked on, or do you mostly do personal injury and bankruptcy? Just ask. And then what are the average fees in cases like mine? I can tell you at Modern Law, our average fee is around $6,000. Now, it's hard to say, obviously. That's not a guarantee that that's how much anybody's going to spend. Some people spend far less. Some people spend far more. But at least having an average gives you some idea of how this firm operates. Your particular circumstances are going to be specific, and you want to get into that with the attorney, but just getting the information is going to be helpful. The next section of questions is, let's say you like this person, you want to move forward. You think there's a click, you think there's a fit. Now we really want to talk about money. So one of the biggest complaints that people have about attorneys is about money. And mostly that comes down to expectations. We found people are happy to pay their bills when they know what to expect. They know what they're paying for. They've opted into it. They don't feel like, gotcha, surprised you. And so many people get invoices from their attorneys and feel like their attorney is literally saying, gotcha, now you have to pay this bill you didn't know was coming. So ask these questions. What do you think my case is going to cost? How often am I going to be billed? What does this fee include? And what are your policies on payments, phone calls, etc.? How am I going to be billed and for what? These questions are worth asking, and it should all be in a written fee agreement, which you absolutely should insist on and make sure is followed. The next set of questions has to do with expectations on communication. Beyond fees, or maybe along with fees, the next biggest complaint that people have about working with attorneys is with regards to communication. Clients almost always want more communication than their attorneys are giving them. So this is something that we can fix with expectations. How long will it take for me to get an appointment when I call in? If I need to talk to my attorney, how quickly can I get in to talk to that attorney? Can I call you after hours? And if I do, can I expect a response? Are my goals realistic? This is important. Not everybody's goals necessarily are realistic, and that's not necessarily your fault. If you don't know what this world looks like or what to expect, then how are you expected to know if your goals are realistic? Ask the question and be open to receiving the answer. Now, let's say this attorney says, no, you're fine. You're fine. We have a nice service dog with us today. It's pretty darn cool. So if you hear some puppy love, that's what it is. If the attorney that you're meeting with says your goals are not realistic, please don't stop there. Please get a second or a third opinion. But if you have 2 or 3 attorneys tell you your goals aren't realistic, these are reputable attorneys who are not afraid to give you the truth, then you really do need to go back to very step 1 and reassess those goals, or figure out an alternative strategy to get what you want, because going through the court system probably won't cut it. And that takes us to our next question, which is, what problems do you foresee? If I have a client who comes to me who has, let's say, unrealistic expectations per the court, then we're talking about strategies that don't involve court. What other pieces of leverage are there? How can we get creative to solve this problem before we say, nope, you got to pick a new goal? And sometimes you do have to pick a new goal, but sometimes there's a way that we can get there that's just not quite as direct as marching through the court system. The next set of questions involves strategy. How will we solve my problems? That's kind of what I was talking about. How are we going to accomplish my goals? How much time is this going to take? How much time should I prepare to spend on this? And is it likely that we're going to have to litigate this case, or can we perhaps settle it? These are some things that your attorney is going to want to know from you. Do you have an existing case number? Do you have any pending hearings? Is it a 4D case? That is a division of child support, or is CPS involved? Are there any other alternative agencies, or let's say grandparents have custody of children? Are there other people that are involved beyond the people in this particular case number? We need to know about that. And is there an existing decree that we're trying to enforce or modify? These are all essential things for your attorney to know in order to be able to answer all of those questions realistically about costs of time and assessing your goals.
So that's really important for people to prepare before they come to that first initial meeting, or so that they can have a better discussion with you on the questions above.
Yes, I mean, it's information that we need to have in that consultation in order to give you accurate information and answer those questions accurately. Be prepared to share the details. Now, here, I want to make sure that whatever is important to you, you share with me, regardless of whether or not it fits under a nice, neat statute. And the best example here, I've got all these questions that you can and should be thinking about before you come in, that we give to our clients before they come in, or potential clients before they come in. But this is the best example I can give. I had a consultation a couple years ago with a woman, and she was telling me about her situation. She hadn't been married very long. She was older, and she confessed essentially that the sex life was really bad. And this sounds like something that's just completely like, what does this have to do with anything? Well, turns out that they didn't consummate the marriage, that they had never been able to consummate the marriage, which meant we were able to get her an annulment. And because she was the primary breadwinner during this marriage where she was older and she contributed this money into her 401k, doing an annulment meant that she was able to keep that money as opposed to splitting it as community property. So that's the very best example I can give you of why sharing these uncomfortable details with your attorney may end up saving you a whole lot of money. And in her case, getting an annulment was a lot simpler and quicker and easier than getting a divorce. That is another reason why you have to be able to click with your attorney. If you're going to be talking about things like your sex life, and you probably are, I'm just saying it happens, then you want to make sure that there's a level of trust there, that you're comfortable talking with one another. There's a cultural fit. Here are some other things that I want you to consider, and we've got lists and lists that I'm happy to share with you and send to you. Do you have religious differences? Do you have disagreements, and what are they mostly surrounding? What are the biggest pain points in your relationship? I know these aren't necessarily related to issues of alimony, but when it comes down to creating creative solutions, having all of that information about what makes the two of you tick, what works and what doesn't, what motivates somebody, makes us more able to get a better result, or at least factor that in when crafting creative solutions. What is your residence status? When did you move here? How long have you been here in Arizona? Somebody has to be here for 90 days in order to file for divorce. That's not true for legal separation. So if a couple has just moved here from Florida and they want to get a divorce, we can file for legal separation, get the process started, later convert that to a divorce, and you're not stuck waiting your 90 days. Something to think about. We want to talk about businesses, criminal history, domestic violence, life insurance policies, post-nuptial agreements, prenuptial agreements, etc., etc. A lot of people put off going to see a lawyer. It makes sense. It's uncomfortable. And maybe you don't need to see a lawyer. Maybe there are enough resources online. You watch our 11-part series and you feel like you have a pretty good handle on things. But in general, going to see a lawyer early is kind of like going to see a doctor early, where you can really head off a lot of problems or kind of strategically figure out what you want to do. For instance, I met with a woman yesterday, and she had decided that she's in like a 23-year marriage, and it's been bad for about 15 years. And it just now has kind of hit her that she's lost herself, and she's numb, and she's almost going to be 50, and she's still just gorgeous, and she has all these things she wants to do, and she wants out of her marriage. But in talking through the specifics of her circumstances, it doesn't make sense for her to file today. That's not her best option given her circumstances. So by talking with me about this before she talked to her husband, before she decided she was going to file paperwork, she is better set up for her long-term goals. Okay, so something to think about.
One of the people on Facebook also brought up a good point of in the questions: do you feel respected by your attorney? Is that something that is on that list of things to kind of make sure that it's a good fit? So
I love that point, because one of the reasons that people don't go see lawyers, or people don't want to see lawyers, is because lawyers are scary and they feel intimidated. That's here on this slide. Or I can't talk to a stranger and I'm falling apart. These are things to think about when you're meeting with your attorney, and your attorney should respect you, should respect your opinion. This is your life. Let's not lose sight of this. Just because we're the expert that does divorce all day long or for years and years doesn't mean that we get to make decisions about your life. Our job is to guide you through the process. That's okay. We got some Facebook Live up in here too. Yeah. So anyway, thank you, whomever on Facebook said that. Brilliant. I love it. Keep looking. If your attorney does not inspire confidence, your attorney was not attentive to you, blew off your questions or concerns, your attorney appears disorganized, distracted, not really focusing, paying attention, the attorney can't follow what you're saying, you don't feel understood. You don't feel understood, how can they help you achieve your objectives? If they don't seem to understand your objectives, move on. Or if you don't have a rapport that you like. All right. Now, what if you have a lawyer and you're trying to determine whether or not to dump your lawyer? And I say dump because it really is kind of a relationship, and it really is kind of like dating. And people have this happens. It happens fairly frequently. And sometimes it's fine, and sometimes it's a big fat red flag. So let's talk about why. You should probably consider switching attorneys if your calls are not being returned, if you don't know what your fees are going to be charged, and if you don't feel like you guys have a clear strategy and objective in your case. You're just not sure what's going on. You just feel like you're kind of reacting kind of in the dark. That's a problem. Try to have a come to Jesus. Try to talk about it. Any good relationship's worth attempts to communicate, but if it's not working, then you may want to get a second opinion. And what do you want? You want attorney too. You want regular updates. You want your objectives clarified, and you want settlement strategies and strategies for your execution of your litigation to be clear. If you don't have those things, you might want to try to talk about it, and if it doesn't work, move on. Up front, you want to ask how you're going to be billed, how your office works, how the courtroom works, how you're going to be charged for copies. Will you be charged in advance? If you're depositing into a trust account, are you expected to put more money in, and when, and how far in advance will you be notified? These are all things that you need to know. Plus, you need to be looking at your written agreement. An attorney can make all the difference in your case. It truly, truly can. And so it's an important decision that is worth you spending time on, which is why we wanted to set aside some time today to go over that. The attorney that you choose must understand you and must be smart enough about the law to help you navigate the system. Now, if you are somebody who has had 2 or 3 attorneys and you've been unhappy with all of them, and you've done a fairly decent job researching them, the problem is you. It just is. And at that point, it's time to really look in the mirror, get a counselor, talk to somebody you can trust and reassess your situation, because you are literally flushing your money down the toilet. And this is one of the things that we are really passionate about here at Modern Law, is protecting people's resources. If we're taking your money, we want to be doing a great work for you that is worth it, that achieves your objectives. And switching attorneys once is usually not a red flag. It's not a problem. And sometimes you've got to do it. But if you're switching attorneys, several times, if you find that you're at odds with your attorney quite a bit, it usually is a sign that things are not going to end well for you. You're not going to like what the judge does. If you don't like what your attorneys do, I promise you're not going to like what the judge does. And you really probably want to reassess. All right, that is all for today. Now we have time for questions, both for people in the office and for our friends on Facebook. So, thanks for coming today.
Thanks for having me.
Yeah. What's going on?
What's going on? So I are we just having some questions.
Yeah.
I am. I feel like I didn't hear.
No.
It's just still be a litigated question. But anyway.
All right. Quick disclaimer. Everybody here in the office and on Facebook has a disclaimer, so that you're aware that I'm not your attorney and this is not confidential and we don't have attorney-client privilege. But we're going to protect your anonymity as much as we possibly can. If you want to get us questions, but you don't want to type them on Facebook because you don't want to see, these are personal questions, go ahead and text us those questions, 480-649-2905. Caitlin will put that in the comments, that way you know. But anyway, with that, we're going to jump into our live question.
So, divorce decree was set in motion already a few months back. Now we're in post-divorce decree where things within the divorce decree have not been resolved yet. And one of those things in the divorce decree had to do with how we communicate and how we actually transport the child and kids around, the minor child's around, so on and so forth. Anyway, that led to criminal charges because I sent a written request for the mom to allow me to take my son to Disney cruise for his birthday. I won a long story short, I won a civil rights litigation suit against the company over my service animal, and I was part of the settlement that was to get my son to trip to Disney cruise. Anyway, he's allowed to travel anywhere within the U.S. as long as she's alerted 7 days in advance. But if he's going outside the country, I have to have written, either one of the parents have to have written consent for that to happen. Anyway, she is very bitter over the divorce, and she, for her own personal reason, said no.
Oh.
She initially told the son, the minor child, that I didn't say that you can go. And then later on, I know she consulted with 4 days later, she sent me a note writing saying I couldn't take him. Well, the trip was already paid for. It was his birthday. He was already told he could go. He was really, really getting on me about it. He was getting on her. So long story short, I took it anyway.
Okay.
So we had a great time.
I bet you did.
so anyway, there's consequences, right? So she initially filed a police report, and then she initially said she didn't want to press charges, and then a week ago, she said now she's supposed to press criminal charges. So now she's filed a police report and put it in a criminal court for, what do they call it?
Custodial interference?
Yeah. No. This is called failure to something about I didn't follow a judicial order or something. Yeah, okay. That's how they got it in the criminal designation.
Interesting.
So if you have an attorney on the family law side and something like that happens,
right,
and an attorney represents you on the criminal side.
Yeah. Okay. All right. Wow. There's so much there we can talk about. So much. But I mean, your question right off the bat is: can the family court attorney represent you in criminal court? Let's back up. First, you haven't been charged with anything, right? She's told you that she wants to press charges.
No, I've been charged.
You've been charged.
I was in court this morning.
You were in court this morning. All right. Well, I'm assuming the penalties are not such that you will get a public defender.
I don't know. Yeah, it was just the arraignment.
Okay. You didn't know if you would get a public defender.
No,
okay.
It was just the arraignment this morning.
All right.
The actual pre-trial is January 4th.
Okay. Well, it definitely depends on the attorney. Some family law attorneys are qualified and will represent you in kind of related family law or criminal law matters. Okay. Other family law attorneys will say, absolutely not. I'm not doing it. So you need to talk to your attorney, and then you need to vet your attorney and decide, do I think this person is capable and competent to represent me in the criminal matter? I don't know how helpful that is.
Yeah, no, actually, that was actually, so I said that's the part one. Part two is, to that question, how does a case that starts in Superior Court or in Family Court, how do they even have jurisdiction to send it to a criminal court or charge under a criminal? If it started in one court,
Right.
what is it? Because literally, if I'm being charged with basically not following the court order or whatever, I forgot what the actual designation is. I'm not being charged with not following the court order, but that court order was set in motion in family court.
Right.
Are they enforcing it in criminal court?
Yeah.
That's the part that I'm confused about. Not to mention, isn't there a jurisdiction issue when I took the kid out of the country? It didn't happen in the court, the place where they're actually charging me. Don't they have to have jurisdiction for that to be in there?
Yeah.
Yeah.
So
I was a lot to unpack.
No, I
Just
can't.
things boggling my mind.
I'm kind of shocked. I'm shocked, honestly.
I am too.
Pretty shocked. So most of the time in this situation, what you've done is you've committed contempt of court.
Just essentially, yeah.
That's what it is. Now, there are civil penalties for committing contempt of court, and there are potentially criminal penalties. Now, I have never seen this situation.
Yeah.
Somebody takes their kiddo on a cruise, and mom doesn't like it.
She's pissed.
Sorry. It's just terrible.
Horrible.
It's horrible.
And here's, let me just put the icing on the cake for you and your viewers. This was after I offered to pay $500 out of my own pocket. I remember this lawsuit was a free trip for my son.
Sure.
I actually offered to pay $500 out of my own pocket for her to attend because it's a big
For
deal.
her to come?
For her to come. My son is turning 10. For his 5th birthday, we were at Disneyland. 10th is going to be Disney Cruise.
Sure.
And 15th is Disney World.
I would like to be your kid.
So I knew it was a big deal, even though it was a very contentious divorce between her and I,
Yeah.
mainly because of her bitterness. Not me, I'm over it. I don't want to divorce her, but anyway. So she, because I didn't pay for her entire trip, she said no. So yeah, so $500 was still more than the amount for her to attend, but it wasn't the entire trip amount. So
Sure.
she said no.
Yeah.
Anyway, so that was just a little tidbit.
Okay, well, I know some great criminal attorneys. If you don't like what's going on, you just let me know and I'll hook you up with some good people. I don't know what to tell you.
My God, no.
It really is.
For me too, I was like, what?
I mean, so the family court is a civil court, and the remedies for enforcing in civil court are civil contempt. Things like paying somebody's attorney's fees or even a fine. It is just unheard of in this situation that there would be criminal charges. Typically, when there's criminal charges, it's for an assault, or I mean, if you break the law, the criminal code, Title 13, then there can be criminal consequences. This, to me, just doesn't really sound like a criminal act, but you and your attorney are going to have to work that out, figure it out, look at all the angles and see what you can do. But it sounds like it may have been worth it.
Yeah, it was actually. I mean, my son's had a tough year dealing with the whole divorce in general, and then I bought the house when I was in Afghanistan. I bought the house for him, and she forced to sell the house because it's a whole bunch of different stuff. So there's a lot of things that's been happening that really has rocked his world, and it was something he needed. So I felt like it was absolutely necessary to take him on a trip, even though I knew it was for it.
Well, and that's the thing. we as lawyers could never ever tell you that you should break a court order. As you can tell from this situation, the penalties can be steep, steeper here than I've really ever seen before for something like this. But these are your decisions, and our job is to give you information, and then you do the cost benefit analysis and you make the decision. And it sounds like you did, and yep, there's consequences, and we'll deal with them. So, any other questions, or Caitlin, do we have other questions?
Yeah, I've got one online there. If you have to go back for changes in parenting plans, do you get the same judge, or is it just the luck of the draw each time?
Yeah, that's a great question. So you have an assigned judge in family court until that judge rotates. So depending on how long your case goes, you could end up having 2, 3, 4 judges. But also, depending on how long ago you got your decree, you could have the exact same assigned judge. So this is something that strategically we want to look at when you are coming back from modification. So one of the things I would want to do is look at your decree, look at what this judge said about you and your situation, look at the circumstances that have changed since then, what you're trying to achieve, and then figure out how likely is it that we're going to be able to get you what you want. So yeah, it's not the luck of the draw anymore. You get to change your judge once before they make any rulings, which is not all that helpful for people who don't know the judges. One of the things that we do is we get to know the judges. We keep track of their leanings. Everyone's an individual, and we get to, sometimes we say, oh, we know this judge almost always gives equal parenting time, and our client does not want equal parenting time. We're going to file a motion for a change of judge, and hopefully we get somebody who maybe is a little bit more open to our alternative plan.
Do you know approximately how often the judges rotate? You mentioned that at the beginning.
Yeah. No, do I know it? Yes, but it's usually supposed to be a 3-year rotation, but it doesn't seem to work that way. Sometimes people rotate much sooner. Changes are always being made, and some judges seem to stick around for a long, long time. So I wish I could tell you. Sometimes they'll change courthouses, and so you'll get assigned a new judge. They might still be in family court, but they're not in your courthouse. And so, yeah, definitely something that we can look at in your given specific situation.
So I have a question, actually, piggybacking off the last question, as far as the judge goes. Like, when you go in for modifications, is there a specific time you should wait before you ask for modifications? Like, is it 3 months, 6 months, a year?
Yeah, great question.
Because my situation just was put in motion in May, and here we are back in court.
All right.
Yeah.
You have to wait 12 months to file for a modification of parenting time or custody, unless the decree is not being enforced or carried out. Then you can file after 6 months. So, but you can't, there is a waiting period there.
12 months. Right.
Here you are, wow. And I think the goal is like let's try to settle into this. Let's really give it a shot. Things are crazy at first, and sometimes they're crazy even after you get divorced, even after you get your decree and your parenting plan, and maybe you need a while to calm down. But it's unfortunate sometimes that you have to wait.
So let me ask you this. Oh, sorry. Is there any more questions? I don't want to take up the...
We have a bunch here, but you're fine. So go ahead. You're good.
All right. So you have, both the parents, you have divorce decree in hand. It literally says, it's funny you said that, and I think it does, and you're saying something about 12 months, and or you have to deal with mediation first before coming back to court. She has a very crafty attorney who knows how to word things on paper. She created this sensationalism that things were a little more dramatic than they were, and she filed no less than 6 petitions to motions to get anything back to court. So things are going back in court. Once the judge sees this information and sees that about 95% of stuff is really not factual and some of a lot of sensationalized, is there some type of penalty for them, sensationalizing the situation to get back before the judge when it wasn't as dramatic as something that definitely could have happened and could have been solved in mediation? Like, judges typically frown upon that, or is there some type of law or some type of ordinance or statute they can say, hey, you violated the statute, I'm gonna sanction you based on XYZ for sensationalizing this situation instead of doing mediation first?
Yes. There is nothing worse than getting dragged into court and having your resources wasted over something as silly as, wanting to take your kid on a cruise, or pickup and drop off times, or whatever it is that people want to fight about. The court system is just not the place to resolve those issues. And so there is a statute, there's many, but the one that is most frequently used is the attorney's fee statute, which is 25329, I believe. And if you are unreasonable in your litigation, you may be ordered to pay the other person's attorney's fees. Now, that can only happen if you actually have attorney's fees. What if you're representing yourself? You're still losing all this time. So there are a lot of other ways to ask for sanctions. And you can get creative here. The Civil Rule 11 allows you to ask for sanctions under certain circumstances. There's a lot of different provisions that would allow you to ask for sanctions. And we need to get creative and look at those and then determine what is most appropriate for you to ask for those sanctions. And then when you have somebody who's really, really bad, year after year after year, and it happens, sometimes they can be labeled a vexatious litigant, which is a super cool word. And if you are labeled a vexatious litigant, then you are not allowed to file anything else without prior permission of the court. So it's hard to get there, really hard to get there. But that is a kind of a last-ditch final slap for people who can't help themselves.
Sort of a follow-up question maybe to that is, even if you wait 6 or 12 months, are there maybe a handful of emergencies that would actually sort of qualify or fall under,
Yes.
modifying it early that aren't, dramatizing it up or sensationalizing it?
Right. Yeah, absolutely. Yes. Mom goes into rehab and the kid has nowhere to live. Dad goes to jail and, et cetera, et cetera. Dad assaults the kids. Mom hooks up with a druggy boyfriend and is prostituting herself out of the house. Et cetera, et cetera. You can always file for an emergency modification if your child is in immediate danger of irreparable harm. That is a high bar.
Yeah.
But sometimes, even when we think that the bar has been met and our client wants us to move forward with an emergency motion, sometimes it won't be granted. It will still get us a hearing sooner than if we hadn't gone. So it's a discussion that we need to have. What's going on? How likely are we to get the emergency order? What are the pros and cons of moving forward with this? That sort of thing.
Another question that came up is if I may be thinking about getting an attorney, what do you kind of expect of me as the client coming into this?
Well, we have the handout that we send that gives people things I'd like you to think about before you come in, and questions that I would find relevant, things that I'd like to know, as well as a list of paperwork or things that we'd like you to bring. And most of that we kind of covered here today.
Okay. Another one that came in.
Mm-hmm.
Can you get an annulment if you've been married for 6 months in the state of Arizona?
Maybe yes, maybe no. To get an annulment, you have to meet the criteria, and length of marriage is not one of those criteria. So an annulment is a super old school concept that essentially your marriage wasn't valid when you entered into it because of some procedural issue or some physical issue. And there's a list of grounds for annulment. But simply being married for 6 months won't get you there. But if there are some other circumstances present, then we may be able to get you the annulment.
Okay. You have any more questions?
I do, go ahead.
You do?
Yeah.
You should
Go
ask
ahead,
it.
yeah.
Okay, sorry.
Dominic.
So, subpoena, I know, if you represent yourself, and you're subpoenaed by the other side, it's obviously easier for his attorneys to know how to subpoena. How does someone who's self-representing, get a subpoena for the, the other side?
That's a great question. I think, and let me just say I could be wrong on this. Okay? I could be wrong on
Validate
this.
this
Let me
answer.
just say right now, I could be wrong. But I think that I remember that only attorneys have subpoena power. I think that individuals can't subpoena documents.
So I don't know this.
Yes, go ahead.
So I guess my question, so obviously judges are supposed to be fair and impartial, right? If you have somebody who can't afford, representation versus somebody who can, the other person obviously has upper hands, have them turn it in that can see the records, and then you, the person who can't, you don't have the power to subpoena. So in that situation, do the judges look at that and say, okay, well, you present all this information that was subpoenaed by your attorney, this person has an argument, but this person doesn't have subpoena power. How is it a fair playing field when there's one person with representation versus someone who doesn't? So one person has subpoena power, the other person doesn't have subpoena power.
Let's just be clear. If one party has a good attorney and one party doesn't, there is no level playing field. There isn't. Okay? We go to school for a gazillion years and then study this all day, and it's just, you are David and Goliath. But David beats Goliath sometimes. It happens. So yes, you don't have a level playing field, but there are ways for you to get the information you need. And we're going to go over that when we talk about disclosure and discovery. So even though you don't have subpoena power, you do have the ability to request documents from the other party. If they don't give it to you, and you have the ability to request documents that they need to go get for you from their bank or whomever you need these documents from. If they don't give it to you, you have the ability to file a motion to compel. You have the ability to ask the court to compel the individual to get the documents. So you don't just show up and say, hey, I don't have subpoena power. There are things that you do. Sorry. I mean that in the best way. But that's why we're doing this, so that you know how to best protect yourself if you are David going up against Goliath.
Thank you.
Yes. What else?
So they put a follow-up to the enrollment question. Is there maybe a place that you know of offhand where you could go to find out what that list of things is? Because they kind of wanted to know if cheating was on the list, and so
cheating's not on the list. I'll tell you right now, cheating is not on the list. It is a no-fault divorce state, and I'm sorry, but nope. That's not going to get it done. Our website has some blogs on enrollment with the list, and I'm not going to try to do it from memory because I'll probably forget this. But if you go to our website and you search enrollment, you will get all sorts of common law grounds. And if you want to email us, then I'm happy to also find that, make sure it's correct, and get it over to you.
Great. Thank you. You have any other questions?
Go ahead.
Do it.
So it seems like I did some research in places before I came. So, I watched your videos, which are very informative.
Thanks.
Thanks for doing them. Helped me out a lot. So it seems like you guys are at it. And I guess this is kind of a personal question, also a legal question. So it seems like out of all the places I've researched, you guys are kind of pro the small guy and have to fight for themselves, right? Doesn't that conflict with you guys actually trying to work as attorneys? And how do you balance that conflict, if you even feel it's a conflict?
We don't feel it's a conflict.
You don't feel it's a
Nope,
conflict?
not at all. Not at all. The bottom line is that 80% of people can't afford lawyers and represent themselves. And those people should have access to information and access to resources. Modern law is kind of 2.0 of our company. And we started out as a firm that was started for the purpose of increasing access to justice. What we found along the way was that isn't best served within a law firm. But the law firm can do a lot to empower people, to create resources, to do things like this. And it's something that we're happy to do. And it lets people know who we are. Like when you hire modern law, this is what you're getting. We are really, really good. We're really, really committed, and we're also going to help the little guy as much as we possibly can.
Fair enough. And so, with that being said, so it's like a different part of your company. I guess you log in and submit information. So, as far as like pretrial statements and other things that have to be prepared, is that prepared by like paralegals or like who?
So I think you're talking about our sister company, Access Legal.
Yes.
Okay, so it kind of goes back to what we were talking about. So Modern Law started off as a company that was for the purpose of increasing access to justice, and we found that it didn't work really very well within the law firm. And so this second company spun off and was created called Access Legal, and that is a legal doc prep company in Arizona that has online legal forms available for free to the public to use. And they're not unlike the forms that you will get at the court, but they're created in Microsoft Word, so you can customize them. So if you take that and you couple it with all the information from the workshops, you can really create a very customized documents for your litigation strategy by using all of the resources. The other thing that comes with Access Legal is a certified legal document preparer. She does not work for the law firm. The way Access Legal works now is it's a $200 monthly membership, and the certified legal document preparer will look at and assist you with any documents that you want to create during your membership. So pretrial statements, anything else. The certified legal document preparer is an experienced Arizona paralegal. She's not an attorney. She can't give you legal advice. But much like what we're doing today, we're talking about legal information. She can absolutely give you that, and we try to give you as much legal information as we possibly can.
Right. Thank you.
Mm-hmm.
So we've got, about 8 minutes left before we wrap up or so. So definitely want to give you an opportunity if you have any other questions, because I don't want to.
There's a question here. My ex is representing himself and running up my lawyer's bill. He calls and sends letters and emails constantly. He knows I get charged every time he contacts my lawyer. What can I do? It happens. Yeah, it happens. I had an opposing party not that long ago that was intentionally harassing me to get to his ex. And he said, I'm going to email you every 5 minutes until you answer the question that I have. And we used it in court. At that point, I told him, look, I'm going to get an injunction against harassment. Knock it off.
Mm.
This isn't substantive. It's not helping your case. I'm happy to work with you to solve substantive issues, but I'm not going to let you harass me to get to your wife, because there was already an order of protection in place. So talk with your lawyer, see what your lawyer can do. One of the things that we've done with other people is we've required them to write letters. And we hate letters. We're a paperless office. We hate it. But sometimes you need that buffer, or, you filter it on your email box. You tell that person, you can send me letters and I'm going to filter these emails so that I don't have to see them. So you got to get creative. We have to protect our clients, and protecting our clients sometimes means we need to figure out how to protect them from opposing parties who are using their attorney to hurt them. Go ahead.
So, two questions. First one would be pro per. When someone's representing themselves pro per, have you been in the courtroom? That's a 2-part question. Have you been in the courtroom with someone that you're the attorney and the person pro per on the other side?
All the time.
Okay, gotcha. So you're just right. You said 80% of the time it's happening. All right. So in that situation, like, what have you seen as the biggest barrier for someone representing themselves pro per? Like, what is the biggest obstacle pro per representation presents to court that you've seen?
Sometimes people represent themselves in court very, very well. The most important thing is that you are organized and deliberate. And that's kind of what we talk about here in the workshop and in the series, and preparing evidence and trial presentation is all about how do you determine what evidence you're presenting and in what order to do it, and how to question witnesses. so that you are very clear going in with what you're trying to achieve and you maximize your chances of achieving it. So I think it comes down to organization, strategy, and deliberate execution of that strategy. I don't know if that helps. It's kind of broad.
So, especially when there's like a time frame, is there a way that you could, utilize like the pre-trial statement, the thing that if they send to the judge ahead of time, like how can you help that kind of play into the strategy?
Yeah. So one of the things that we talk about a lot in the Decode Your Divorce book, I didn't talk about that, but we have a book that was written. Sorry, there's a book. We give it away during our free consultations, but during our paid consultations, right? Sorry, thanks, Caitlin. But you can buy it on Amazon, you can buy it here, and it is a step-by-step guide to Arizona divorce directions. My best attempt to give people directions on how to represent themselves. And one of the things we talk about in the book is the pretrial statement. And one of the things we're going to talk about in this workshop is the pretrial statement. The pretrial statement is everything, your whole case boiled into a document that goes to the judge before your trial. Many, many times you will walk into court and the judge will already have a pretty darn good idea of what they want to do based on that pretrial statement. One of the things that I like to tell people is if you have money for one document, for one piece to have an attorney help you, have an attorney help you draft the pretrial statement. It is your facts, your background, your legal argument, your rebuttals to their legal argument, your exhibits, your objections to their bad behavior, your position on sanctions and attorney's fees. It's everything. I use it as my outline when I am in court. So, to Caitlin's point, or the question online, you can use your pretrial statement to maximize your chances in court and cover ground that you may not get to in trial. Because one of the constraints that you've got is how much time you've got. And you have to choose, if I only have an hour to present my evidence, what's most important? And there will be things you do not get to. So know in advance what you're not going to get to and how you're going to get around that.
Is there a length? Like, that sounds like a lot. So is there, like, are people walking up in the court presenting a 5-page pretrial statement?
I have drafted probably 30, 40, 50-page pretrial statements.
Oh, wow. And the judge reads all of it?
Yeah. If the issues are complicated enough to warrant that, you don't want to waste anybody's time. So you don't want to use more words than necessary. But if it takes 50 pages to talk about a very complex situation, a very complex legal argument, then yeah, that's what we'll do.
Last question on the pretrial statement. Sometimes the judge will mandate a joint pretrial statement. Mm-hmm. Most of the time, as a matter of fact, both times, is what I've seen. What if you just can't, you're not seeing eye to eye with the other side? How do you present your own pretrial statement instead of doing a joint?
That is so challenging. We struggle with this.
So when they say they want a pretrial statement, that's what they want, a joint, they want a joint?
It depends on the judge, okay? So some judges, you can call the JA. They are your friend. You can call the JA and say, hey, I'm having a hard time. Judicial assistant, yeah. So if you're having a hard time coordinating, you're getting up to your deadline, you can't get a response. This happens. You can call the JA and say, hey, I can't get it to you. I'm not able to get you a joint pretrial statement. I have a separate one ready to go. And they will tell you one of two things. Great, send it over. Or sorry, the judge only accepts joint pretrial statements.
So what are you going to ask?
If you can't get it, I guess you file yours and it says joint and it says the other person's positions and it's blank. I mean, you have to work with what you got, right? I mean, and then you have to show how many times you've reached out to try to do a joint pretrial statement. It's a challenge.
Okay.
Yeah. We're about out of time for today. So everybody will be back in 2 weeks, right? No, first and third
Tuesdays.
First and third Tuesdays at noon will be our workshop series, and we'll go through these 11 parts. And we're going to put the video up on YouTube so that if you've missed certain sessions, you can go back and watch it, okay? Thanks so much, and offer feedback if you want this format different or if you have things that you didn't get answered, let us know. And we'll talk to you later. Have a great day.